remember the police pension scam, that trial of some members in the civil service, about is it 40 billion naira, of which an Abuja High Court did sentence Yakubu Yusuf for 2 years imprisonment with an option of fine of 750,000 naira for his alleged culpability in the 23.3 billion naira fraud. Well, you all heard that judgment, and by the way, we do have a report about it. But we're joined in our Abuja studios this morning by Mr. Festus Keyamo, who is a legal practitioner. Morning, and thank you for joining us. Well, yes, indeed, we had a lot of reaction from Nigerians about that same judgment. Some could not just understand it. They don't understand how law works, how plea bargain works, what it is with the judiciary. They need some explanation, but you also are aware of that report. What can you tell us about it?
Well, thank you very much. That judgment came as a surprise to many of us who are even legal practitioners and also members of the public. Many people cannot still fathom how the court arrived at that type of sentencing. And this is because the magnitude of the crime, the amount involved, is not just commensurate with the punishment that was meted on the suspects, on the accused person, I mean. So that, I think, is the annoyance of many Nigerians on this issue.
Yeah, the issue has to do with what loads of people have been complaining about, saying, well, we had to amend the charges and drop a whole lot, knowing full well what was at stake by the time we said, okay, we're having just 3 of them against Yakubu Yusuf. So could you please expatiate more? How does it work, knowing full well that you're trying to amend charges? Don't you go with the weighty ones before the judge?
Well, you see, that is the problem with plea bargaining. My learned friend and brother, Rotimi Jacobs, did that trial, and I had cause to speak with him on this issue the moment it was handed down. And we spoke on phone, and I asked him about the rationale, how they came to that conclusion. And I can assure you that Rotimi Jacobs is one of the very best we have in prosecution at the commission. I know his capabilities. He said he was never part of that arrangement, and that it was a surprise that the judge or the court reached that conclusion. You see, the problem with plea bargaining is that you, as a prosecutor, you may be calculating the time and expense it will cost you to go through the whole hog of trial. And so when the accused person says he wants to plea bargain, normally, because it's a give and take thing, you will be required as a prosecutor to drop the very serious charges. Because the man is now willing to say, look, I don't want to go through the whole hog of trial. That may take you, in some cases, 10 years and more. And in some cases, you are not sure whether your witnesses will still be alive, whether some witnesses will still be within jurisdiction for you to call to do their, to come and give evidence. So, as a prosecutor, you weigh these options at times and you say, okay, look, let me go with the plea bargain because the society is not interested in many cases at the length of time the person may spend in prison custody, but the society is just interested in the fact that the person is tainted with some kind of criminal record, the person is convicted, so that the person does not find his way into public life again. And especially if you have the prospect of recovering a lot from the person. Now, Alede, the problem is that plea bargaining is not totally wrong. I have said it over and over again. The problem with plea bargaining is when you do not get a good deal out of it, like this present case. If somebody steals 28 billion, for example, and through plea bargaining, I can recover 27 billion, and the person has 10 houses, I can recover 8 or 9 of the houses. and the person is prepared to plead guilty, and the person is supposed to go for 5 years, I can take you in for 1 or 2 years. That is a good deal for a prosecutor. So why people are complaining about plea bargaining is because of the very ridiculous, deal that the state gets out of it in most situations, like this particular one. And then I think that before this discussion ends today, we need to talk about what pushes a prosecutor or prosecutors to this desperate level of trying to plea bargain. What are the problems with our justice system? How can we reform this problem, the justice system, to take away these problems, so that we can have a near perfect criminal justice system? These are the problems. So there are problems with prosecution too. People should realize that.
Okay, so since in principle plea bargaining, nothing wrong with it, because I mean some other countries in other climes do practice it and they seem to be getting the better of it. But in our own circumstance here, from your perspective, do you think that since it was an attempt to improve justice delivery and now we don't seem to be getting the best of it, at least in 1 or 2 cases that have been handed down, do you think we should actually jettison that plea deal system and see how we can improve on our justice delivery system?
Well, I agree entirely with you that we need to concentrate on reforming our justice system, justice delivery system, our criminal justice system especially, so that we can jettison this idea of plea bargaining, because it is subject to abuse in our system. Because even as a prosecutor, you cannot impose on a judge the type of terms he should impose on an accused person when you do plea bargain with an accused person. We have had instances where after you reach an agreement with the accused person, the rest is left to the judge, to decide. The judge is not bound in many cases to take what both of you have agreed with, because it's not a civil case where there are terms of settlement you give a judge that he must adopt. The judge has a large, discretion in imposing sentence when it comes to criminal cases. So I do agree with you. For now, we should jettison this idea of running away from trial, getting the easy way out by plea bargaining. We must go back to our justice system, criminal justice system. How do we reform this? And of course, I have a very few suggestions. Sorry, I have few suggestions on this program, because with all sense of modesty, or allow me the modesty to say that I have prosecuted and defended at the highest levels. I have also got convictions at the highest level. I have gone through trials. In most cases, in all the cases I have done for the commission, I have not done any plea bargain. In the case of Bode George, we went the whole trial. I called, more than 10 witnesses and, tendered all kinds of exhibits. And we went, through. So I prosecuted at the highest level. I've also defended at the highest level. I've defended people for treasonable felony. And I have seen both sides of the coin. And I have the advantage of seeing exactly where the problem is in our criminal justice system. And so let me tell you this. People complain about the length of trials of some of these criminal cases in court, especially corruption cases. But of course, you realize that the Commission, the EFCC, even the ICPC, the NDLA, in many cases, they are ready to go with their trial. We go to court with our witnesses. The defense, in most cases, comes up with all kinds of applications. And these applications, interlocutory applications, as to jurisdiction, as to the sufficiency of evidence, and all that, they take it first of all to the Supreme Court. While they are traveling to the Supreme Court for the first 8 years, they ask the court of first instance to stay the trial while they go and determine the preliminary issues first at the Supreme Court. You realize that because of this, the first generation of governors, their trials are still on, whilst the second generation of governors, some of them have come to meet the first generation of governors now. So it's all a mess.